Good evening, ladies and gentlemen. Thank you very much for coming this evening. This is a joint Marques and IBIL event, and I'm the Marques side of the equation. My name's Roland Mallinson. I'm on the board at Marques, and so I help run this event. We're very grateful to be having UCL host us here. I do, for those of you who've been before, I do a little mini plug for Marques, in particular on behalf of the Amicus Curiae team, which I get involved with as well. And so all I say to you is, for those of you that have particularly interesting cases that might go on appeal, and you wish some backup perhaps from Marques as a European Trademark Owners Association, we would very much welcome you bringing the case to us at an early stage, as early as possible, please. We're not now just talking about cases going to the General Court, the Court of Justice. We've just recently intervened in a case in France at the national court level, and that we were accepted as an amicus in that. So we'd be more than happy to get involved in national UK cases or national cases in other jurisdictions. But the game is to come in and get our involvement early, is all I can say, because it takes time to get us on board. And we also need to consider whether or not we are willing to support you. We'd like to do so, but on the whole, we're doing it. Just remember that Marques, unlike ECTA and INTA, is a brand owners association. So we will be looking at it from a brand owner's perspective. On that note, I think plug over. I will hand over to Sir Robin, who is our chair this evening, and he will introduce the panel. I look forward to seeing you all after for drinks. Thank you. Told I have to clip this on you, Robin.
Yeah.
Yeah.
Thank you. Good evening, everyone. We've got the usual list of about 20-25 questions, of which we'll be lucky to get through 10.
Sweet.
Some are more difficult than others. We debated them now at tea, and with no firm conclusion about anything at all. I'm going to start with one of the questions, which is more about the personal satisfaction of a judge. Do you enjoy your cases being reported in the newspapers, the mainstream newspapers, maybe? Or would you rather you just quietly got on with the job and nobody said anything? And have you noticed that some people are aiming to get their decision on the news? Who would like to start with that one? Yes, please, Virginia. Oh, by the way, I haven't introduced the panel because you know who they all are.
No. Thank you. I think today we cannot be out of the social media debate and reporting and blogs. We feel all, at least in Alicante, very proud when there's a debate generated by our decisions, whether there are arguments against or people like or dislike the case. I think it's good. We are there to, this enriches the debate and gives more arguments. The issue I see is that we are not really able to engage in a response. And we are now reflecting at the Boards of Appeal at the office to think about a policy. If, for example, we are commenting our own decisions or commenting the decisions of the neighbors in another board. So the debate is good, yes, and I like it, and in the blogs or in social media, but we need to reflect on how we the authors of the decisions engage in that.
How does the Trademark Registry feel about when there's some decision of a hearing officer gets all over the papers?
Well, I'll speak for myself. I'm quite happy to have my decisions. I enjoy having my decisions commented upon in the legal media. The mainstream media I'm fairly ambivalent about. But what I do find annoying is when you find out things about the case because the party said more to the media than they have to the tribunal.
Yes.
And that's very infuriating when you think, well, they say, well, we lost despite the fact of X, Y, Z. And you say, you never put in evidence that X, Y, Z. And you're complaining now that it wasn't taken into account. So you do feel like coming back and saying, well, excuse me, This party's complaining, and look at the way they run their case. Now they're saying something wasn't taken into account. So yeah, sometimes it can be a bit frustrating, but we obviously make a point of not engaging in those sorts of debates or pushbacks against people. But I've had a couple of those in the last year or so. One was called Bull Hour, which was a family business up against Red Bull in relation to soft drinks, and the other was some gentleman who wanted to raise Tesla for catering services, and found himself on the wrong end of a decision and got very upset about it and went to the press. And again, I found more about his business and what his motives were from reading the article. I don't think he actually filed any evidence at all in the case. So there we are. That's what I think about it. It can be very frustrating on occasions, but goes with the territory.
James?
Well, I think the safest course is to be completely indifferent to anything that is reported in the press, and in particular not to get drawn into any discussion about it. You decide the case, and that's it. So it's pretty simple as far as I'm concerned.
Functus officio, which is the Latin for your function.
Yes.
Douglas, have you found yourself at the end of any of this?
Well, in the day job, all publicity is great, win or lose. But as a judge, quite happy to be below the radar. As Allan said, comment in legal press is fine, but you don't want to be in the Daily Mail. The other thing I do notice is that from sitting as a judge, I do a bit of it. Very rare that anyone says to you, good job here. You only get the losers complaining, and no one ever says, how much effort you put in, no one says that was a good job. Which is a bit coy. There we go.
I once found myself praised in the Sun.
Oh, wow.
Oh dear. What top judge gets caught?
It was Hyde Park where I found against Mohammed Al fired. The Court of Appeal reversed me wrongly, as they later said in a later case. Right, we've probably done that question to death. Does the behaviour of parties in the way they handle their cases upset you sometimes? For example, where there's a famous mark and the defendant or the other side doesn't admit it's famous. Everybody knows it's famous, but they don't admit it. So the first party's got to spend a lot of money proving it and so on and so forth. Does that affect the way you view the case? And do you think there should be a simple way of dealing with people who don't make admissions of obvious things? For example, an immediate order as to costs. James, you can go for that one first. You're the toughest of them all. You've got the best position.
Yeah, no, I mean, if people take up stupid positions, then they're going to pay for it.
Have you ever made an order making them pay for it straight away?
No, I can't remember doing anything like that. But I better get my excuse in early, because I've been a judge for 3 years now, and I've only been let loose on 2 trademark cases. But that's because we've got so many patent cases. So I'm losing my grip on my qualification to be classified as a trademark judge. No, I haven't. That hasn't.
You produced another volume of Curly in that time.
Oh, I know, yeah. But I rely on my fellow authors.
Right, well, I think we'll probably leave that one any further, but I think the power of sanctions from a court should be real. Post-sale confusion. Recent Court of Appeal cases have said that post-sale confusion is an established part of both EU and domestic law. Is that really so, or should it be so? What do you think about that, Douglas?
Yes and yes.
Oh, that was quick.
Well, it came out, I think, in that Orange decision that Richard gave a few years ago, and people hadn't really thought of it up to that point, although there was that BP case about the green motorway sign thing. But when that case came out, it was a whole lot of discussion in settings like this about post-sale confusion. Is this new or something? I remember thinking at the time, well, why is it new exactly? Isn't this as old as the hills? So I think, yes, it always has been part. And yes, it should be, to be honest. I mean, still confusion, still damaging to brands. Why should it not be?
Yeah, I agree.
I mean, I'm a mere first instance judge, so I do what I'm told by the Court of Appeal.
Well, of course.
Especially written.
Does the office take into account post-sale confusion if they get evidence of it as relevant?
Yes. In fact, it gets argued surprisingly often. Well, I suspect it's going to be argued more often as a result of the recent decision. Often it's tied into this question of what is the average consumer's level of attention? Because during the selection process, which is the norm, you can gauge how much attention a person's paying. If it comes up in the case of post-sale confusion, the argument is often linked to an argument, well, people won't be paying much attention because, they're not now buying this product, they're sort of watching somebody else wearing it or something like this. And therefore, you should factor in a lower level of attention, and they could be confused in that context. I remember I had a case many years ago where somebody was arguing that it was to do with stripes on football boots. And the argument was, well, if you're sat at the back of a stand and you see a footballer on the other side of the pitch, will you be able to tell whether he's wearing 2 stripes on his boots or 3 stripes on his boots? And I thought, well, this is, if you're at the back of a stand, you might not even be able to see his feet, let alone how many stripes he's got on his boots. But it seems to me that we've gone quite a long way away from, the protecting the functions of a trademark, because if you're gonna say, well, that's a relevant likelihood of confusion, that would lead to all sorts of marks being held to be too similar. Because if you've got being too similar that you could mistake them from 300 meters is enough. When you're not paying much attention, the bar would be very low. I think that's one of the reasons why in Picasso, the Court of Justice said that the most important point when it comes to assessing the relevant consumer's level of attention is during the selection process, so that you don't go off and attach a lower bar when it comes to other points in time, including post-sale confusion. But yes, I agree, it's a real thing. It's come up in quite a few cases I've dealt with over the years, including, I remember one many years ago, which was the colour green applied to oil. And the argument was that it could be a trademark because people have paid to have their oil changed. And if they wanted that particular brand, which was the one that dyed it to green, you could check your engine afterwards to make sure they put the one in that you'd ordered. And if it wasn't the right colour, you knew they'd given you a cheaper oil. So the great example of a trademark function attached to, in that case, a fairly non-conventional trademark. So I agree, it's a real thing. It has to be taken into account, but it shouldn't lead into these more sort of speculative arguments about sort of people seeing things from sort of, too far away, or whilst they're rushing down the aisle of a supermarket and they're not paying attention properly and they pick up the wrong thing. Well, it shouldn't lead to that sort of thing becoming actionable.
Have you found post-sale confusion evidence being offered in the office?
No, because as you know, and has been mentioned, the court tell us to check the moment of purchase and where's the confusion actually in the moment you take a decision. But I mean I like the reasoning. I like where it comes from.
The oldest trademarks we know are on the bottom of pots in the building just round the corner, the British Museum. They're thousands of years old. And if you saw the same mark on 2 different pots, you say, well, it's made by the same man. And the other way, in a real modern world, where you might want to know, is spare parts. You undo, something's gone wrong with your machine, you take out the bit and you try and find that, and you find the trademark of the bloke who made the bit years after you bought the thing. I think it's absolute nonsense to suggest that you limit it to pre-sale.
We had a recent decision in Testarossa, Ferrari Testarossa case, which clearly they didn't like it because we said there's no use for cars. There's some left use for spare parts and toys. And well, they are unhappy, so they are before the General Court. We'll see. 50 or 60 years after the car was launched.
This is a very sort of ordinary one in some ways, but it's a very sort of personal one. How many of you have started writing a judgment, thinking you know the answer, and changed your mind? Has any one of you done it?
All. I bet. All the time.
All the time?
Confess.
Actually, most trademark cases, I know what the answer is. Although there were one or two appointed person decisions where I didn't. And for those cases, you just got to work through all the issues and the answer comes out. That often happens in patent cases, by the way. Perhaps more.
More.
But there are quite a few trademark cases where the answer is pretty obvious, actually.
Alan, you've written hundreds of decisions. You ever change your mind as you started or after you started?
Yes, not in a huge number of cases, but certainly in some cases I've changed my mind. Usually because I've made a decision based on what I expect the evidence to be able to show. And then when I look at the evidence, I find there's holes in it.
Yes, that's true.
My logic path has to be rerouted. Yeah.
Inconvenient holes.
Yes.
That's right. And sometimes I end up in the same place, even though I might get there by a different route. And sometimes I find I can't get there at all because there's just too many gaps in the evidence, and frustrating. You have to make a decision that you're not 100% happy with. But yes, it does happen, and it can make life. It does frequently makes life more difficult when you expect to be able to find certain things proven, and in fact, what you actually find is that either complacency is not.
Same as James. Not, I think, in trademark cases, because you read the papers and you have a view, and as Allan says, you sort of think what the evidence is going to say, and you don't really change your mind that much. Patent cases, it's happened a couple of times. But I do remember vividly, it was some short application, and thinking the answer was clearly X, and I'd written out some notes, and it became almost about 10 minutes, that was the wrong answer, so I had to change it. And I didn't really have the opportunity to go away and sort of rewrite it all, because the decision was needed instantly. So I remember that pretty vividly. But that's 1 out of 100, maybe.
That's quite significant if the light it throws on the European Patent Office's decision principle was they give you the answer on the day and won't give you the reasons later. They're stuck with what they've written, what they've said they're going to do.
Yes.
Okay.
Does anybody in this audience think that's a good idea? Does anybody? This is serious, because I think that one day they've got to change that in the EPO. Nobody thinks it's a good idea, all right?
Well, it depends how confident you are in the result.
Yeah.
If you are confident, then you can announce it. But if you need to go away and think about it, the best thing to do is go away and think about it.
Even if you are confident, time you come to write it may go wrong. It's much better safer than sorry.
Yeah.
Again, sort of by judgment writing, how often do you go and ask somebody else who's not involved in the case, another judge, what do you think of this? Do you do that, Allan?
Yes. In fact, all the hearing officers in the IPO do it. We have a system called peer review, which means that somebody else challenges what you tries to challenge. If they can find a challenge to what you're proposing to say, and then it's sort of very helpful at bringing out inconsistencies in what you've said. It doesn't very often change the outcome, but it's very helpful sometimes, because as you get into a case, sometimes you lose sight sometimes of the reasoning as to why you went one way on a particular ground and perhaps another way on another ground, and somebody points out to you, actually, that doesn't really sort of tie in very well with this. It allows you to sort of have a second thought about it and put it in a more rational form. So yes, we do. We don't debate the cases and sort of come to a collective decision. But in terms of somebody going through it and saying, is there anything inconsistent or obviously illogical about this, that happens routinely. We also sit occasionally as panels where you do have to have a debate with the other panel members as to what the outcome is going to be. But the norm is a single hearing officer. In company name cases, we routinely sit as panels of 3. So we are used to discussing and have always so far been able to come to a consensus view.
We are panels of 3, so we exchange a lot among ourselves, but sometimes, as rapporteur of the case, I want to see another colleague. For example, I need to check a cultural concept or linguistic concept, and I want to be sure that what I am told in the documents is exactly that. I remember a case The mark was Karelia, and of course it was pleaded. The two marks were identical, one for cigarettes, another for, I think it was class 4 products. And the issue is that Karelia is a region of Finland and with a lot of specific characteristics also share with Russia. So I went to sit with a Finnish colleague who is also a member of the Second Board of Appeal, who happens to come from this region, in order to check, all the information we had and to send back the case to the examiner saying, well, you shouldn't have accepted the mark in the first place. But you need, in a multicultural context, you need to be allowed and free and go to, to visit concepts which are difficult to apprehend from the documents in an opposition, for example.
I didn't know about the peer review system in the UK. It sounds like a very good idea, actually. Unfortunately, we don't operate that. Although we do, I work in the Rolls building, and all the judges' offices are on the 4th floor all the way around. And say I get bowled a case about tax or charities or something that I didn't practice it, I will be able to find a judge somewhere on the floor who knows all about that. And everybody's very amenable to you going and saying, like, just give me a few basics on this. And it works in reverse. So although I don't do all the trademark cases, a lot of people come and ask me, they're not asking me to decide the case for them. They're asking, well, how does this concept work? And it's good fun, actually, that sort of discussion. And it helps everybody because it's a two-way process.
Douglas, do you get much chance of doing that or not? Probably not in trademark matters, but in other things.
Well, sometimes a bit. It does happen a little bit, but as everyone says, it's quite limited. And often I find it's the process of explaining your thinking to them that's the valuable bit, not really the response.
Yeah.
The most valuable response sometimes is someone says, "Oh, don't know about that." That's a good response. Oh yeah, I'm obviously going off beat there. But if it's, well, maybe, and then quite often I think, well, that wasn't particularly valuable, but at least I've clarified how I've thought about it myself. Actually, one thing I must say as well is it always strikes me as funny. I do a bit of crime sitting as well, 15 days a year. And I always find it odd when full-time crime judges say, do you think this sentence is about right? Class A drug dealing or whatever.
I had all the products lined up next to each other in my room in L'Oreal and Mellor, and John Mummery came into my room, looked at them and said no. He would have even held the historic ones non-infringing. This is a more technical one. Is it becoming the case, like Picasso and Messi, where a mark is particularly famous, so that a somewhat similar mark is held to be not confusing in a way that it wouldn't have been if the mark had been less famous? Is this a problem we're noticing, and is it unfair if it is happening, or is it not a problem anyway? Anne, what do you think of that?
I think it's an area of quite a bit of confusion. So the two of the cases that I think the questioner had in mind was the Picasso-Picaro case and the Messi decisions in Europe. Of course, Picasso is not a trademark, but is a trademark, but it's not just a trademark, it's the name of a famous artist. And Messi, of course, is the name of a famous footballer. So when you're talking about conceptual identity counteracting visual and oral similarities, these cases tend to be about people or names that have got significance beyond the brand. They are famous names. In fact, I dealt with one about a year and a half ago where the earlier mark was rebellion and the applicant's mark was extinction rebellion. And the argument was likely to confusion. And I said, well, I don't think anybody's going to confuse extinction rebellion with an earlier trademark for just the word rebellion, because the significance is, people's minds are so different. And of course, there's two words against one and all that sort of thing. So I said, but there was a really quite intense argument in that case about whether what we were doing was dumbing down or discounting the distinctiveness of the earlier brand by just going to conceptual difference. And that was the view I took, is that you could do that where it had an identity beyond the trademark. But if it's purely its identity as a trademark, so if we're talking about something like Intel, for example, you can't say, well, Intel's very well known, so there's the concept, and Intello hasn't got the same concept, so therefore you have to sort of find no likelihood of confusion between two very similar names, because the trademark reputation of either of the marks. No, the case law is that the more distinctive the earlier mark and the better known it is, the greater the likelihood of confusion. So if it's purely a trademark reputation, it doesn't come into conceptual comparisons. But if it is a name which has got a broader significance, like name of a famous footballer or an artist or whatever, or a movement like Extinction Rebellion, then you can factor that in, because that goes to the concept and it brings to mind not just the trademark idea.
There was Kojak.
TV cap.
Kodak had a little fight in the 1970s. I would have thought you can tell the difference between film and lollipops sucking detective. But still.
I think, Sir Jacobs, if you allow me, I think there's an issue at the moment with the comparison of names, at least with family names, because the court has recognized in Luxembourg, in Rolf versus Wolf case, that they have taken two different and parallel case law lines. One saying that the name is a concept, and another saying that there's no concept in a name. And of course, that means that if the name is famous, you first have to say, well, there was a concept, because I'm saying this is a family name, and I recognize that as a family name. So we are a little bit lost at the moment, and I agree with Allan's analysis, but the court has admitted that they have taken two different positions. Therefore, the boards, we can take whatever of these two positions. But I think if there's a great knowledge, not saying reputation, about a particular name, well, the conceptual difference will make the conclusion of no likelihood of confusion. I had the opposite case, Messi versus Masi, okay? After the Messi-Masi. He tried to challenge the very old Spanish registered mark for sport articles. And we said no likelihood of confusion.
And he couldn't produce any, but it was an old mark.
Yeah, because in fact the line of products it's a family business. This Masi, they are in Catalonia, and they were very well known for very particular items linked to cycling, and Messi, of course, is well known for clothing.
He's very good at football, but he's never played football on a bicycle.
Yeah. So, but there was much less publicity talking about media talking about our cases. Of course, our cases was not commented as much as the Messi-Masi other case.
I mean, I think Allan explained it very well. I mean, these cases, Picasso, Picara, and Messi-Masi, they are said to give rise to the neutralization doctrine or principle. And I think it's really dangerous calling it a doctrine or a principle, because all it is, it's a particular example on the facts of the cases where a conceptual similarity happened to override any visual or oral similarity. And it's very dangerous calling it a doctrine because you feel in the case is actually telling you something.
Has somebody actually called it a doctrine of neutralization?
Yeah, it's in the...
It's in Thomson Life. It's from there.
Yeah.
Thomson Life talks about neutralization. Not invented by us.
Well, not so much to add. I'm not sure this is a really new thing, though. I mean, I was thinking of old cases like Rolex and Rotex, and you mentioned the Kojak one. So I mean, I'm not sure as a doctor at all, as James says, but is it that new? Otherwise, nothing to add.
But applied to names, I think that's
Yeah, that's new, actually.
applied to persons.
Well, those were kind of notional. Oh, Kojak was a notional person. That was the whole point.
Okay, Kojak.
I don't suppose anybody here remembers Kojak.
Yes.
How many do?
Some people. Well,
More than I thought. This is a question really for, and I want some people to think of this, and I'm surprised about this one. We are seeing many, many less applications for interim injunctions in trademark and passing off cases than there used to be. Most of our cases, when I started the bar, were done on that. You either got your injunction, defendant went off and did something different, or you didn't, in which case you gave up. One or two cases went on. Neutrogena was one where they failed to get an interlocutory injunction and said it is confusing and went on and proved it at trial, but that was very rare. So basically, trademark cases were done a lot cheaper then than they are now. Because the interim injunction, you get the papers ready, you write them a letter, 7-day answer, go for them on the 8th day. They give them 2 weeks to put their evidence in, 1 week for evidence and reply. Judge hears it in a month, case over. Why isn't it happening now? And I'm going to invite people in the audience to join in if they can think why. Is it just that they don't realise it can be done?
Yeah, I think it's very difficult to give an answer to this. I mean, when I first started, I was John Baldwin's pupil. And I remember going to the motions court and he would be doing 10, 12 cases a day. I mean, there were 2 motions a day a week at that point. He'd be doing 10 or 12. And a lot of those were Anton Pillars. But that was because there were a lot of pirates around at that point. And there were far fewer pirates now, actually.
I think that may be true.
I think also the analysis of interim injunctions is more sophisticated now. The analysis of the irreparable damage argument is more sophisticated.
In the trademark case?
Yeah. Yeah.
Well, anyway, the upshot is we don't have them.
One of the 2 trademark cases I've done was an interim injunction. So that was AU vodka. So,
Yeah. Doug, have you done any as a deputy?
No, I did one as counsel a few years ago. I got one in Franken Nike, it was called. And that was, a small company against a giant Nike, and we stopped this massive handout, and that went to the Court of Appeal as well. And that actually is the last trademark injunction case I've seen. And that was about 5 years ago. And it was an IPEC as well, which made it a bit unusual. Well, I think the 2 reasons are people just don't think they're going to win them, and people think they're too expensive. I think there's not a lack of knowledge or lack of, people don't really.
Whether they don't go to court at all, the thing is, it's going to be, this is the cheapest way to get it sorted.
yeah, if you get your injunction.
Yeah, if you do.
Yeah, well, you got it sorted by losing as well.
Yeah, I mean, it's an expensive thing to do, an interim injunction application. And so, plus, trademark proprietors aren't necessarily as rich as patent people. The patent can
Yeah,
throw
that's
money
true.
at it big time and try it on. And, also, you do get them in patent cases all about clearing the way if people have failed to do it. That's a well-known area. You can get injunctions. Outside that, I'm not sure anyone's getting injunctions for any intellectual property right.
Yeah, temporary injunctions.
Interim injunctions, yeah, final injunctions. Of course you get your fines. So.
Yeah. It's interesting. I think it's a pity, really.
Any views from the room there?
Yeah.
Yeah. Anybody else know why it's not happening now? Yeah.
Yeah, I think from a client, when you're advising clients on injunctions, the cost undertaking and damages is huge exposure for them, as is the cost, as is the risk when the case James referred to, the injunction was declined, speedy trial ordered. So I think there is just that fear now amongst clients. It was always a lottery, but I think it's more of a lottery now and it's more expensive.
Has it got spoilt by sign limit a bit? I don't know. Because the basic rule when I started was if you thought you were going to get into an injunction, because they were confusing this, and when you went for it, and on the whole, you can work that out ahead.
Actually, your point about speedy trial is a very good one, because I think judges are much more ready to give a speedy trial now, which slightly takes the point away.
Yeah, of course.
Yeah.
You look at me.
Yes, ma'am.
Since your one, I think that you since then was the Hendricks little one about when she was in Scotland. Actually. That was a preliminary injunction. And then, but it didn't prove to be so cheap. When I was involved, we actually ended up on appeal, but it was upheld. So yeah, it did take, by the time we got through that process, and the Scottish process is a bit more painful for the English one. It was about 5 months later, and then it took ages to get a costs order. It was the officials.
Well, the mysteries of getting a costs order in Scotland we'll pass over. Yes.
I would say that I mean, cost is definitely a factor. And clients will also look at other options. So we have a office in Glasgow, and we are regularly instructed to go get interim instincts in Scotland as an alternative to the UK.
Because of England, not in England. You go in Scotland rather than England. That's very interesting.
Okay.
And it regularly resolves the dispute the way you described.
Yeah, but normally reasonably plain cases just go bang, they're dead.
Can I add, actually, on that, because there was an oddity out of the Hendricks case, which was the first time the Scottish court decided that it was able to give a preliminary injunction that covered England, which I thought was really weird, because the English courts, I'm sure, have been merrily giving injunctions that covered the whole of Scotland for years.
Well, we didn't say what the injunction was. It was an injunction the defendant be restrained from. We didn't say whether that worked in Scotland or not. I don't know. Nobody ever went and did it after the injunction had been granted only in Scotland. Where would you bring your contempt proceedings? Like England or in Scotland? Wonderful questions. Well, can anything be done about reducing litigation costs in England? I mean, people have always asked that question since, I don't know, possibly the first time we had a court.
Yeah.
And they ask it all the time, all the world, all over. Is there anything we could do? Make things a bit better? Make bundling easier? I gather there's a requirement to have lots of bundles in some places.
Well, I mean, now we almost exclusively deal with electronic bundles, which they're much cheaper to put together, which is sometimes a bad thing because you get more stuff in them. But at least you're not destroying a forest, giving however many bundles to all the people in the court. I mean, in terms of reducing cost, it's really the responsibility of the parties. And if they're not prepared to be sensible, then they're going to ramp up the costs. And it's unfortunate that they only realise later when they've lost that they perhaps should have thought about the issues in a slightly more sensible way. I mean, we've got lots of routes through which we can try and reduce the costs. So you've got IPEC, shorter trial scheme, etc. And it's up to litigants to use those processes.
Oh, any other comments on that? Anybody else got a good idea as to how we can make it cheaper? What about sending it to an arbitrator just on the papers? I'm just suggesting that.
Replace the judge with AI.
Oh, right. Is there a problem about defining the relevant consumer, in the sense that when you want to prove reputational or acquired distinctiveness, you narrow the concept of the consumer and say there's a small group of people, but they're the only people who matter, and they know me very well. But when you come to average level of attention, you want to say, oh, they're that average sort of guy. Is there a problem of different concepts of the average consumer in different parts of trademark law? Do you think there are any problems or not?
This is Alan's question.
I've got that written. I've got AJ written on the left here.
Actually, the question is it a problem? I don't think it is a problem. People like to sort of focus narrowly when they're trying to show acquired distinctiveness because it gives them a smaller pool in which they've got to show they've acquired reputations. And sometimes then when it comes to arguing about confusion or unfair advantage, they want to sort of cast the pool much more broadly, so that they bring in groups who are more easily confused or taken advantage of whatever than they wanted to focus on when it comes to the first question as to whether they had a reputation. So, I mean, the short answer is you can't have it both ways. You can't have cast the pool narrowly when it comes to showing what your reputation is and then extend it much wider when it comes to sort of trying to bring in whether people are going to be affected by the scope of the reputation when it comes to relating to mark. You can see this in a case that came up about, must be 5-6 years ago, the London taxis case, where in order to show distinctiveness and reputation, the claimant wanted to rely upon the relevant consumer being essentially somebody who bought taxis, or a taxi firm and that sort of thing. But obviously the logic of that would be actually was the context of acquired distinctiveness. The logic of that would be you're looking at quite a specialised group, and it'd be relatively more straightforward to show acquired distinctiveness if the sign had some distinctive character. But the Court of Appeal felt that actually the users of taxis should have been taken into account as well, and in that broader group, it was much more difficult to show distinctiveness. I had come across a similar sort of problem, only the other way around. A few years later, I dealt with a case involving the shape of the Land Rover Defender model in particular. As the party that was trying to show an acquired distinctiveness had taken on board this earlier judgment in the London taxis case, done a survey that went right across basically anybody who would buy a vehicle at all. They didn't try to focus it on people who were interested in the 4x4. And as a result of that, the level of recognition I thought they'd be able to show turned out to be very much lower. And not only that, there was quite a lot of noise in the survey results they put forward, because some people who weren't really interested in 4x4s didn't know the difference between Land Rovers and Jeeps, and so therefore there's quite a high level of misattribution of this shape to things that, particularly to the Jeep company, when I felt in that case it would have been better for both the applicant and for me to have understood in amongst this group of people which of them would be in the market for buying a 4x4 and which of them are just people who might use a car from time to time but really got no interest in the 4x4 market. That would have been, I felt, more helpful. So but I think the applicant unusually had been very fair about it and very objective, followed the London taxis case to the letter and cast the net very broadly. I thought in that case the result turned out to be, for me, less helpful than if they'd actually done both things. If they'd actually asked the wider group, but also asked, would you be in the market for buying a 4x4? Then you might have been able to work out, in that market, was there a stronger degree of at least recognition than the headline indicated, and the less confusion about what was a Jeep and what was a Land Rover, which is another confusing factor. So, yes, you need to think very carefully about who your relevant average consumer is when you're trying to show acquired distinctiveness. And the answer may be even more complicated. It may be actually there's more than one relevant group of average consumers, and some of them may be more important than others. So you need to think about that as well, I think, for these surveys or going forward witnesses.
Yeah, I think in some cases it's pretty obvious that one party is playing switcheroo with the other consumer, and in other cases it's much more subtle. So you've got to actually think about it quite hard, and then you realise they're still doing the same, pulling the same trick. Yeah.
Anybody else want to comment? This is a rather clever question. I don't know who thought of this one. For each of you, it may not apply to you, James, because you've only done 2 trademark cases. But the question is there a trademark case in which you were not a judge, but you wish you had been? And if so, Dare you say which it was and why?
I had we decided a case on the issue of territoriality of use. This is the mark was the standard, and it was attacked by a revocation for non-use in the European Union, and in fact the proprietor showed that they had very luxury hotels in Miami, Los Angeles, and New York, and that they were talking or planning a hotel in London. And we had to rule on whether, advertising that you have hotels in the USA through Booking or Trivago or TripAdvisor was use of providing accommodation in class 43. And in my board, we concluded no. And then the General Court said that we were all wrong because, in fact, anybody in the EU could perfectly book. And, of course, these hotels received people from the European Union. Now, I would have loved to be the rapporteur in Luxembourg and to rule exactly on what does it mean when you have to prove use of services which mean, for me, at least that was the reasoning, a tangible, something that you can touch, like a bed, a bathroom, etc. We are not talking about promoting, advertising, or marketing hotels around the world, in which case I agree, the fact that you have promoted the service. But if you are talking about putting a premise to have accommodation in a hotel, which is by definition not possibly virtual, how you can say that 3 hotels in the US is used in the EU? I was completely shocked by so I would have loved to have the opportunity to confirm my own decision. It's not because, I don't know if you share that feeling. I don't have this sort of possession feeling vis-a-vis the cases we rule on. But it was the first case where the court had to say what is this territoriality of use in a global digital world. Mm. And in the discussions we had among us, we arrived to the idea that some services may be absolutely virtual, where you don't need any physical anything, like marketing, advertising, telecommunications. But there are services which, by definition, imply some minimal things. Although there's this glamping concept where you can, go in a very luxury tent in the middle of the desert. But a hotel accommodation means and requires at least some minimum things. So, unfortunately, there's no other case. So when we analyze a judgment that has an annulment, we gather every month and we analyze this. Of course, we decide if this is a trend or not. And with this case, the standard case, we have a question mark, because of course I pleaded not to follow the General Court. But we are looking forward another case in which we have this discussion. So I said to Vice President Papasavas, I would have loved for one day to be there, sitting in Luxembourg in that case.
Well, when you are reversed by a higher court, there were 2 reactions. One is, damn it, I made a mistake. I can see I've got it wrong. And the other is, Lord, forgive them, for they know not what they do.
Yeah.
And I'm going to ask this. Oh, yeah, go on.
It's a bit of a dangerous question, this, because you just think back to the cases you lost and you think, now that I know what the answer is, I could have done this.
Yeah. I'm going to ask this question in reverse. We didn't discuss that. Is a trade case in which you were a judge, which you wish you hadn't been.
That's more
difficult. You had no time to think of that one. Any? If none come to mind immediately, No surprise. All right. AI and trademarks. First of all, there were two questions. One, how do you think it's going to affect trademarks generally? And particularly, though, how is it going to affect you as judges? Who would like to start with that? James.
Can I start?
You can start. Okay, you go. Of course.
Privilege of the ladies. What I have seen, well, first of all, in the office in Alicante, I have to tell you, we have created a tech watch group, which is animated by the person responsible for AI in the office. But we, all the services are represented there. And we exchange, we brainstorm about how it's affecting us and is affecting us. And 3 weeks ago, we had a big gathering of this tech group. And we brought examples of how this is affecting us. And we have seen, and I am curious to know if you have seen that, statement of grounds or observations clearly coming from a machine. And in our cases, it's even worse because there's not the fact that there's no coherence in the arguments. It's the fact that the language you cannot follow because probably they have put the ChatGPT in English into a Google Translator or Deep Law, whatever, and you don't know if this is Spanish, French, Italian, Polish, or Czech. And we couldn't. What can we do with this? You know, you have to summarize because we summarize the arguments of the party. How sometimes we put seek when it's a sort of strange comment or use of words, but when it's the whole 27 pages, it's just something you cannot summarize because you don't know what it is. And other colleagues say, well, go back to the lawyer and ask them to produce something that makes sense. We don't know, but this is happening. And in our case, it's worse because it's the language issue. And of course, we have seen law firms that don't master the language of the procedure, going through, writing in their mother tongue and then translating. And you see that you read, you understand that there's some sort of Google Translate behind. But at least you can follow the line of arguments. But we have seen cases, I don't know what they are talking about. For example, calling the board the Senate. Okay. If the Senate could reverse, okay. And that's one thing I'm very worried about because that means that I have to produce a communication asking for, again, producing something and then leave the other party the possibility to answer. I mean, this is, I'm worried about what are the powers. And the other case is the use of AI as a tool for help the decision to be more, better. And we don't have to say that we have to talk about that. It's not a taboo. It's there. So yes, AI can be a fantastic tool. For example, if you have a list of goods and services of 27 pages and you are comparing and you are in page 39 and you don't know if you have forgotten something in class 3, which is at your first page. So if you can ask ChatGPT, dear ChatGPT, have I forgotten? Yes, you have forgotten aesthetics. That, I think we all should welcome these kind of things. Just that quick check. Or you have a mark applied for very strange goods in class 1, which is a class that I don't particularly like, because there are some terms which you don't understand. And then the earlier mark is in class 2, but you have the impression that this is all about the same thing. You're talking about coatings or this chemical substance, and you ask GPT, can clarify me, put me an example whether these goods, these words correspond to the same thing. That sort of help, I find it fantastic. Better decisions, more argued, or guides you to a different check. Yes, always under our control. But for me, the most worrying thing at the moment in AI is this sort of documents that are produced in a funny language, new language, that I cannot summarize.
Well, one of our exam questions this year is going to be a proposition of intellectual property law given by ChatGPT. And the question is, what, if anything, is wrong or right about the above? And that's quite a good way of frightening the students that they better not be using ChatGPT, because we know there's a big problem with it. But at the same time, a really clever exercise. Now, how much is the office using, the British office using AI?
We don't use AI in decision writing. I've never used it. We do see quite a lot of gibberish in some of the arguments and the pleadings, but then again, we saw that even before they were.
No. Don't you see it more now? No?
No, not really, no.
Okay.
At least I don't, anyway, but yeah. Perhaps I'm just not recognising it. I just assumed it was just more gibberish.
James, you got any comment on this? You've probably have you seen much gibberish coming in? Yeah, lots of it, but for years.
Lots of Well, actually, in the trial I'm doing at the moment, there is a very long witness statement, and there are certain paragraphs that are accused to have been written by ChatGPT. I mean, actually, it doesn't matter at all. But there is a suspicion because the language just gets very quickly.
Yeah.
What? Anyway, basically AI, I think, it's currently very dangerous. It is going to improve, but I still think we're going to have to think very carefully about anybody using it. And if people put submissions in that are drafted by ChatGPT, I think they should expect to have them rejected.
A better solution.
We should be looking for rules, maybe a court rule. No submission should be written by ChatGPT.
Yeah.
Senior partner to be told if it
specifically.
Well, maybe we should put the question to the Civil Procedure Rules Committee.
Yes.
That'll take years.
Douglas, how do you...
Well, two thoughts. One is, they have quite an interesting talk from Colin Burst where he said it's quite good for triaging box work, because box work is the least glamorous bit of judging. It's also paper applications and letters to judges and all sorts of things. Not really necessarily a court hearing as such. But if you get the AI to go through and just summarize it for you, you can work out, oh, that's a 3-hour job. Oh, that's a 10-minute job.
Yes.
And, so you don't actually have to read it yourself to work out. So you think that's quite a good idea. I think it's a good idea. That'll make a difference. So far as decision-making is concerned, I heard quite a good story about a cancer lab. In fact, it was 2 cancer hospitals, and both the results from the 2 hospitals went to the same place. They had an AI to tell people had cancer. And it was actually quite accurate, but they didn't know how it was working. And eventually they worked out, the reason it worked was Hospital A put the x-rays or whatever and a metal marker on the top left, and Hospital B put it on the top right. So the AI worked out which was coming from Hospital A and Hospital B, and then just used the average for Hospital A and Hospital B. So it was quite accurate, but in this really roundabout ways. And if you actually try to use it for a substantive decision, you get the same thing, wouldn't you? You wouldn't know how it was doing it at all.
Well,
the regulation on AI was voted today.
what did they vote?
There's a regulation by the EU, and I understand that the Parliament has agreed today by a vast majority, and now has to be signed and agreed by the Council. I think there are some interesting prohibitions there, in particular if there's an evidence of infringement of copyrights and things like that. But we have to think about how this is going to impact, and I'm sure this will impact the work on all EU agencies. We have to. I just received the news this afternoon that the regulation was voted.
All right, it's been voted on. Do we know if anybody can understand it?
Well, no, we know. We can ask ChatGPT, but I'm concerned about the creation of the agency, because there's an agency that is supposed to take care of the issues, but I don't know which sort of issues. For example, the problem I just mentioned. If there is an EU agency on artificial intelligence, can I, ask them to give me the possibility to refuse to accept, to say there's no statement of grounds because they are generated by artificial intelligence? I don't know exactly how this is going to work because we are all, absolutely all, touched by artificial intelligence. But there is an agency foreseen.
Right, better move on, I think. Social media and user-generated content has changed what goes on. Because once upon a time, companies put up their advertisements and they were all directed at the consumers and the consumers couldn't answer back. Now they do. It's a two-way process. What difference has that made? Has it helped us getting a better idea of consumer perceptions? Or is it just more noise? Have you got a view on that, Alan? Have you got evidence coming in about social media?
Yes, I think it's almost a sort of routine part of every evidence that you look at now. Social media, people want to tell you how many followers they've got and how many people have viewed, their sites in the last few years. And indeed, you might get some evidence of what people have been posting about their products or whatever on their site. Occasionally, it's helpful because sometimes you can see from the date of the post, what was going on at particular points in time. Sometimes it does the points they make about the brand or whatever it might be. Sometimes sort of feeds into one of the arguments that the party's putting forward about how it's perceived. So sometimes it can be quite helpful. It does create a lot of noise because it's very difficult in terms of the followers, for example, to know when it was they acquired all these followers because they don't usually tell you when all this happened. So you're just looking at events after the relevant date almost always. And the other thing is that the numbers sometimes can be misleading. So you look at it and you think, well, that sounds like a lot of people. You've got X number of followers or X number of people that visited your site. But you have to bear in mind that some of these social media accounts are not sort of geographically limited. So this could be over a very large territory in which people have been looking at this site. Also, it's difficult to know what it represents as a proportion. So there's no substitute for market share evidence, for example, to say you've got 10, 20, 30, 40, 200,000 followers. It might help you paint your picture in totality, but it doesn't no substitute for saying what your market share is in a particular market. I think sometimes people mislead themselves into thinking that it is. If you just show you've got so many thousand followers, and then when you look at it, you say, well, I don't know where they all are. I don't know when you acquired them all. So all of a sudden, the value of the evidence in that context suddenly starts to plummet. And if you put all your eggs in that basket, you could be left high and dry. So I would say, yes, it helps to paint the overall picture of the brand and its significance to people, but it's no substitute for market share and turnover figures specific to the relevant jurisdiction.
How's the social media going in Alicante?
Well, we have social media everywhere. I exactly the same feeling as Allan. As an argument for acquired distinctiveness, we had a case for a multimedia mark of the famous Turkish chef Salt B, who filed the thing he does with the salt on the meat as a multimedia mark. And when we refuse it for meat and restaurant services, he said, "But I have videos in YouTube and on Instagram that have been seen by 14 million people." Yeah, okay, but then where and when and exactly these issues about territoriality, proof of date, etc. And we didn't refuse it because it was a social media evidence. But we refused it because it didn't comply with the
Might have all come from South America.
Yeah, well, first of all, his first restaurant is in Turkey, so, and he has a restaurant in New York. And so that's one type of line of arguments we normally use in acquired distinctiveness. Now, on reputation, of course, so far, I think we have not accepted a proof of reputation only on the basis of social media. Very difficult to do that because you don't have the share, you don't have the proportion. I mean, nothing will replace a very good a very well done survey. Now, I draw your attention to the last week judgment from the General Court on Rihanna again determining trademark law, because there was a discussion about the validity of a design of Puma, and the General Court agreed with the Third Board of Appeal, saying that the picture of Rihanna showing these new shoes destroyed the novelty of the design. So you have to be very careful when you are putting new items in the Instagram or TikTok account of people that have millions of followers, because it has an effect on this kind of things like novelty. But the issue of social media is, for example, the possibility of giving a certification of the dates or the origin where this is coming from. I'm not close, and I'm not against taking on board social media, of course, but we have the constraints we have in the law.
Okay, from the likelihood of confusion viewpoint, there are two things to bear in mind. One is, of course, we're not allowed to do surveys anymore. That's him to floor in the Court of Appeal twice.
Oh, they didn't say that.
I know, but they're greatly discouraged compared with.
Well, you've got to be good surveys.
I know.
Nothing wrong with that. That's what we did in GIF Lemon. It was a good survey.
At the same time, we've had this massive growth in social media, and increasingly you get a stack of social media evidence. And I have very mixed feelings about it, because sometimes it is clearly just morons in a hurry, just typing something bang off. And then in that AU vodka case, the claimant came along and said, oh, we've got 10 or so absolutely clear instances of confusion. And yet when you looked at the chain of the messaging, it proved the exact opposite. So you've got to be careful with social media.
Yes.
Tell me.
Douglas?
Well, I agree with what everyone said thus far. The evidence itself is usually a bit useless, but clients think it's great. And it's cheap and it's free, so they're always pressing. Tell the judge how many followers we get. So you get that pressure, and sometimes it leads to something else. You're talking about the postings. The Comic and Glee case, we had a grand total of one confused person, and we got that because she posted something on Twitter saying, "When they first came out, I thought they were connected," and so that was actually valuable. But it wasn't valuable because it was on Twitter. It was valuable because it pointed us to the witness.
Yeah.
Right, there's going to be one more, and then we're going to stop. It's a very loaded question in the way it's phrased. I'll read it. In lookalike cases, to what extent are judges taking account of, or willing to take account of, the large body of consumer behavioural science research, which makes it clear that the elements of packaging which most influence consumer purchasing decisions are colour, shape and artwork, with brand name being far less important?
Yeah.
Far less important than trademark lawyers and judges mistakenly think. You can't get more loaded in a question than that.
I wonder who posed that one.
And if so, how can the courts benefit from this knowledge without costs spiralling, with both parties having to hire experts, create reports and cross-examine their opponent's expert? James.
Well, I mean, this debate about lookalikes has gone on for decades. I mean, it was live when I first came to the bar, and it's still live. And I mean, unless there's a legislative change to say, for example, lookalikes can be stopped, I don't think we can take account of this sort of thing. I mean, I completely get what you're talking about, really, because I remember once a solicitor phoned me up and said, go down to Asda on the A3. It's a big supermarket. And the solicitor said, go and have a look at the aisle where they sell Twix. So I did. The whole aisle adopted the colour and the packaging of Twix. And so you've got the own brand, you've got Twix. And I mean, everybody knows that the leading brand is used as a signal for the lookalikes. And the lookalikes are cheaper. But, you know, until somebody says they're either taking unfair advantage or, you know, you can't get away from the likelihood of confusion. I mean, the tests are there. And if it doesn't fit, then the lookalikes are going to survive.
Yeah, yeah, go.
Well, the question was consumer behavioural science.
Yeah.
This idea that lawyers and judges have that the name is the most important part of packaging, when in fact behavioural science shows the opposite. It's colour, it's shape.
Well, fine. Come and prove it.
So that's the point. So
Yeah.
what sort
How
of
do you do-
evidence supports going to accept that? Is it the behavioural science evidence, that's a wealth of it, or is it expert evidence, which is expensive for the policies to lead? So it's either do you put the research evidence in, or do you call in experts to the court and the other side can cross-examine?
What is the expert in, he or she?
Consumer behavioural science, specifically for packaging, a lot of research in.
Well, I mean, I'm not going to tell you what evidence to bring.
You'd have to call somebody and say, I'm an expert, this is the position, and nobody, and as a result of this being the reality, you should be the lawyer then says, the judge must infer that there is deception or confusion after all, although you can't prove it any other way. I mean, I wouldn't buy it for a moment myself, but never mind.
It's not deceptive. The argument isn't deceptive. The argument is...
Well, he's asking for change of law, as James says. He's saying, if you want to say...
No, it's unfair advantage.
Well, but there is no such tort of unfair advantage.
Well,
There's a trademark infringement.
10-3 infringement.
Oh, if it's a trademark, but this has nothing to do with the trademark. This is all about.
This is trademark packaging registration.
Well, anyway, I think it's very difficult to debate this in the absence of actually looking at the packaging. Some, as we know, some lookalikes have been stopped.
Alex. It just hadn't changed.
Yeah.
Even without that evidence.
Yeah, that's it.
Yeah, but I mean, the question was about the case where you would bring that evidence. We'd say, well,
How do you do it?
bring it,
How do
you
you do
know,
it
cheaply, I think was the essentially.
Well, if it's a big brand and whatnot, I couldn't care. If this is a big brand, they're going to and against a supermarket. It's not worrying about the expenses. Tuppence compared with their advertising spend. It's not. This is not a litigation cost problem.
Yeah, but the supermarkets are very clever at doing this.
Anyway, they don't want to sue the people. The big brands don't want to sue them for quite different reasons. And they're their customers.
But the recent case, the Thatcher's case, for example,
Yeah.
it's not a big brand. I think you've got a mistaken position. I mean, I understand that Henry's and Red Bull and those, but actually Thatcher's, what was that? Sausage one, wasn't that? Cool. So they're not exactly big. They're not exactly big brands. What's happening is that they're coming out with new innovative products, and 6 months later, lookalike comes out, and they want to try and stop it. And we were asking the question merely to say, how can we save them money?
You're certainly not going to do it by. I don't believe it's going to be realistic. The big brand. I mean, still litigation costs are. I know they're a lot, but compared with this, what's involved in most of these businesses, they're peanuts.
The answer is preliminary injunctions.
Preliminary injunction's not a bad idea.
Is it?
I was just going to say, if you talk about the Warren Butcher's case, I think that was passing off, and the real problem was lack of confusion.
Yeah, I seem to remember some passing off I did about a Milton pork pie. And it was Walls, and it was Mrs. Thatcher's husband that was on the board of Walls. I think they did something quite clever about that to avoid publicity. I was a High Court judge at the time, and it came into court, had one look at it, and it disappeared. And the product disappeared too. Right, we are done and dusted, I think. Thank you, all the panel. They've been brilliant, haven't they?